Equality before law, Article 14. Article 14 declares that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Thus, Article 14 uses two expressions, equality before the law and equal protection of the law. The phrase equality before the law finds a place in almost all written constitutions that guarantees fundamental rights. Both these expressions have, however, been used in the Universal Declaration of Human Rights. The first expression, equality before law, is of English origin, and the second expression has been taken from the American Constitution. Both these expressions aim at establishing what is called equality of status in the preamble of the Constitution. While both the expressions may seem to be identical, they do not convey the same meaning. While equality before the law is a somewhat negative concept implying the absence of any special privilege in favor of individuals and the equal subject of all classes to the ordinary law, equal protection of the law is a more positive concept implying equality of treatment in equal circumstances. However, one dominant idea common to both the expressions is that of equal justice. In State of West Bengal vs. Anwar Ali Sarkar, AIR 1952, Chief Justice Patanjali Sastry has rightly observed that the second expression is corollary of the first, and it is difficult to imagine a situation in which the violation of the equal protection of laws will not be the violation of the equality before law. Thus, in substance, the two expressions mean one and the same thing. Equality before law. The concept of equality does not mean absolute equality among human beings, which is physically not possible to achieve. It is a concept implying absence of any special privilege by reason of birth, creed or the like in favor of any individual, and also the equal subject of all individuals and classes to the ordinary law of the land. As Dr. Jennings puts it, equality before the law means that among equals the law should be equal and should be equally administered, that like should be treated alike. The right to sue and be sued, to prosecute and be prosecuted for the same kind of action should be same for all citizens of full age and understanding without distinctions of race, religion, wealth, social status or political influence. Equal protection of the laws. The guarantee of equal protection of laws is similar to one embodied in the 14th Amendment to the American Constitution. This has been interpreted to mean subjection to equal law, applying to all in the same circumstances. It only means that all persons similarly circumstanced shall be treated alike both in the privileges conferred and liabilities imposed by the laws. Equal law should be applied to all in the same situation, and there should be no discrimination between one person and another. As regards the subject matter of the legislation, their position is the same. Thus, the rule is that the like should be treated alike and not that unlike should be treated alike. Article 14 permits classification but prohibits class legislation. The equal protection of laws guaranteed by Article 14 does not mean that all laws must be general in character. It does not mean that the same laws should apply to all persons. It does not mean that every law must have universal application, for all persons are not, by nature, attainment or circumstances in the same position. The varying needs of different classes of persons often require separate treatment. From the very nature of society, there should be different laws in different places, and the legislature controls the policy and enacts laws in the best interest of the safety and security of the state. In fact, identical treatment in unequal circumstances would amount to inequality. So, A reasonable classification is only not permitted but is necessary if society is to progress. Thus, what Article 14 forbids is class legislation, but it does not forbid reasonable classification. The classification, however, must not be arbitrary, artificial or evasive but must be based on some real and substantial distinction bearing a just and reasonable relation to the object sought to be achieved by the legislation. Article 14 applies where equals are treated differently without any reasonable basis. But where equals and unequals are treated differently, Article 14 does not apply. Class legislation is that which makes an improper discrimination by conferring particular privileges upon a class of persons arbitrarily selected from a large number of persons, all of whom stand in the same relation to the privilege granted, that between whom and the persons not so favored no reasonable distinction or substantial difference can be found justifying the inclusion of one and the exclusion of the other from such privilege. Test of reasonable classification. While Article 14 forbids class legislation, it does not forbid reasonable classification of persons, objects and transactions by the legislature for the purpose of achieving specific ends. But classification must not be arbitrary, artificial or evasive. It must always rest upon some real and substantial distinction bearing a just and reasonable relation to the object sought to be achieved by the legislature. Classification to be reasonable must fulfill the following two conditions. 1. The classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and 2. The differentia must have a rational relation to the object sought to be achieved by the act. The differentia which is the basis of the classification and the object of the act are two distinct things. What is necessary is that there must be a nexus between the basis of classification and the object of the act which makes the classification. It is only when there is no reasonable basis for a classification that legislation making such classification may be declared discriminatory. Thus, the legislature may fix the age at which persons shall be deemed competent to contract between themselves, but no one will claim that competency. No contract can be made to depend upon the stature or color of the hair. Such a classification will be arbitrary. The true meaning and scope of Article 14 have been explained in a number of cases by the Supreme Court. In Re Special Court Bill case, Justice Chandrachud, as he then was, reformulated new propositions to be followed regarding the applicability of Article 14. This has been rightly criticized by Mr. Sirvai as making the well-settled principles unsettled and creating confusion and uncertainty and encouraging litigation. The principle laid down by Justice Das in Dalmia's case has not been disputed by Justice Chandrachud, and therefore there was no need to reformulate the same unless it was necessary to add something to the existing principles. In view of this, the propositions laid down in Dalmia's case still holds good governing a valid classification and are as follows. 1. A law may be constitutional even though it relates to a single individual if on account of some special circumstances or reasons applicable to him and not applicable to others, that single individual may be treated as a class by itself. 2. There is always presumption in favor of the constitutionality of a statute, and the burden is upon him who attacks it to show that there has been a clear transgression of constitutional principles. 3. The presumption may be rebutted in certain cases by showing that on the fact of the statute, there is no classification at all and no difference peculiar to any individual or class, and not applicable to any other individual or class, and yet the law hits only a particular individual or class. 4. It must be presumed that the legislature understands and correctly appreciates the need of its own people, that its laws are directed to problems made manifest by experience, and that its discriminations are based on adequate grounds. 5. In order to sustain the presumption of constitutionality, the court may take into consideration matters of common knowledge, matters of report, and the history of the times, and may assume every state of facts which can be conceived existing at the time of the legislation. 6. That the legislature is free to recognize degrees of harm and may confine its restrictions to those cases where the need is deemed to be the clearest. 7. While good faith and knowledge of the existing conditions on the part of a legislature are to be presumed, if there is nothing on the face of the law or the surrounding circumstances brought to the notice of the court on which the classification may reasonably be regarded as based, the presumption of constitutionality cannot be carried to the extent of always holding that there must be some undisclosed and unknown reasons for subjecting certain individuals or corporations to be hostile or discriminating legislation. 8. The classification may be made on different bases, example, geographical or according to objects or occupations or the like. 9. The classification made by a legislature need not be scientifically perfect or logically complete. Mathematical nicety and perfect equality are not required. Equality before the law does not require mathematical equality of all persons in all circumstances. Equal treatment does not mean identical treatment. Similarity, not identity, of treatment is enough. 10. There can be discrimination both in the substantive as well as the procedural law. Article 14 applies to both. If the classification satisfies the test laid down in the above propositions, the law will be declared constitutional. The question whether a classification is reasonable and proper or not must, however, be judged more on common sense than on legal subtleties.